It's very common these days with design and construction projects for the mechanical, electrical, plumbing systems, MEP, and fire protection systems, FP, for the MEP, FP systems to be designed and built by the same party. So that in many cases that is a design build subcontractor or somebody that is hired by the general contractor to both design and construct the MEP FP systems for a project. It's something that 20 years ago I didn't see as much, but these days it is extremely common on projects for the design team, the architects and the engineers who are retained by the owner to not be responsible for designing the MEP FP systems. And this turns some of the basic assumptions that people go into construction projects with on their heads. So it can be helpful to think about graphs and lines of construction contracts. So over here you've got the owner having a contract with the lead design professional, say it's an architect, and then the architect has a subconsultant agreement with an engineer. Usually you think about this is the place where most of the design comes from, and these have the sort of contract that you would expect to see for design services. Contracts that have appropriate clauses for agreements between owners and real estate developers and the design professionals that they employ, agreements that have the sort of insurance and other terms that you would want to have if you were an owner or a developer and you wanted to make sure that you had a good outcome on your project, that you're able to complete it to the standards that you'd like, and to have recourse in the unfortunate event that there's claims. Then over here, you've got the contract between the owner and the general contractor, and then many subcontract agreements underneath. And when I say design build MEP FP, I'm talking about one of these subcontractors, a design build MEP FP subcontractor that is going to be doing the design work. And so unlike the agreement between the owner and the design team over here, which is going to have the traditional design professional type terms, on this side, when you've got the agreement between the owner and the contractor, and then you've got the subcontracts, typically those agreements are going to be focused on the sort of risk that comes with construction, not design. And yet here we have this little nugget of design. We've got this little design build project that is on the construction side of things. And so, there's two things I want to talk about today. One of them is practical. Okay, and it has to do with how does an owner ensure if they are allowing the MEP FP systems to be designed and built under the general contractor, how do they make sure that they know what they're getting and they're not just getting an MEP FP system that's behind mystery door number 2. And the second thing that I want to discuss is what happens in claims circumstances, because thinking about the different lines of contracts that I was referring to earlier, if you want to bring a claim for design malpractice on this side where you've got the agreements between the owner and the design team, you're typically going to have this sort of insurance agreements and the contract clauses that would be appropriate for a design malpractice claim, but it's a little bit more hazy when an owner possibly has to bring a design malpractice claim against a contractor, particularly if the owner doesn't have a direct contract with the design build sub that did the MEP FP design and construction. So let's get to the first issue, ensuring that owners have a say in what is being designed and built on their behalf. If we think about the traditional way that design is done by the design team working directly for the owners, there's some very there are tracks tread in the snow. There are railroad tracks for the train to chug down with the design phase, right? So we know that you've got schematic design, and then it gets eyeballed and approved, and you've got design development, and it goes to the owner for approval and budgeting exercises, and then you've got construction documents that also get approved and they get priced, and the design professional will put out specifications that will say what is expected of the contractor when they go out and they begin their buyouts, and then you've got submittals by the contractors, and they say, okay, here's the HVAC system that I want to purchase, and the design team looks at it and they either approve the submittal or they take some other appropriate action. So when you have all of the design coming from a design team that was retained by the owner, you've got all these checks and balances, and the owner is able to really understand what it is that they're buying. But it's a little more hazy when you allow the design to be prepared by the subcontractor that is going to be doing the installation. There's nothing inherently wrong with it. There are many advantages to having design build MEP FP, and I would never dissuade any of my clients from taking advantage of that. But you have to think about, if you're not going to go through the traditional design process and approval process, how do you know what you're getting in terms of, the MEP FP systems? And it's a question about process, it's a question about contracts. And there's a couple of things that well-advised project owners and real estate developers do. And one of those things is to create performance standards, a performance specification, where the MEP-FP designer is not unbounded to just design whatever system they want. But the owner would say, that the performance specification, for the air conditioner is, I am looking for you to design a system that would have an air conditioner that is capable of maintaining an interior temperature of 76 degrees when the outside temperature is 100 degrees. That's a huge oversimplification, but that's an example of a performance specification. And so, an owner that doesn't want to be surprised by what's behind mystery door number 2, when they find out what their MEP-FP system is like when it's designed and built by a subcontractor outside the normal SD, DD, CD's specification submittal process where the design emanates from the design team, having, performance specifications or, bridging documents or something that would set out what is the standard, what is the outcome, what does the subcontractor that's designing and ultimately building the MEP-FP systems, what standards do they have to meet, okay? So that is sort of, that's the what, is what would a well-advised owner or real estate developer do? They would have some input, okay, on what is required. They would dictate certain standards. And, the examples that I gave right now were highly oversimplified. This can be, a very substantial undertaking that an owner would, usually engage somebody to help them out with. So we talked about the what, performance specification. Now let's talk about the who, and who is going to help the owner set out these standards. Well, some would argue that it's got to be somebody other than the general contractor and their subcontractor that's going to be doing the work. It might be the architect or the engineer over on this side of the contract chain, the design team. They're not going to be designing the mechanical, electrical, plumbing, or fire protection systems, but maybe it's appropriate for them to help the owner to specify, what it is that they're looking for. So it could be a member of the existing design team, or it could be what is sometimes referred to as a criteria professional. This is typically also going to be a design professional, an architect, or an engineer under the in a direct contract with the owner. That would help prepare these standards. And this is going to be, somebody that has a very good understanding of building performance issues, life cycle issues, what you want the mechanical system to do today, what you want it to be capable of doing in 10 years, bearing in mind issues like that, and then setting out what are these standards, getting them incorporated into the contract documents so that the owner has some ability to dictate what it is that they're looking for from the contractors. Because and this is not to cast aspersion on contractors, but they're very understandably focused on time, construction duration, and also construction costs. To the benefit of owners. Owners don't want to overpay, and so sometimes when you have a contractor that is, bumping up against a pricing constraint, and they go to the owner with a value engineering idea, hey, we can, cheapen the MEP-FP design and we can save you money. There's sometimes a moral hazard there because, the owner might not be happy down the road with what they've gotten. And so when you, as an owner or developer, just say, yeah, I'm just going to let the GC hire a sub and they're going to design the system without putting any guardrails around it, there's a chance that you can have your expectations disappointed as the project owner or the real estate developer. The other thing I want to pivot and talk about is claims situations when you have an MEP FP system that is designed and built by a subcontractor that is hired under a contract with the general contractor. And I want to caution you that this area of law is very complicated and nuanced. But generally speaking, you have the greatest ability to bring claims against a party that you have a contract with. Okay? And so if you are the project owner and you do not have a contract with the designer that is going to be designing your MEP FP system, if your contract is with the general contractor and then it has a subcontract with the MEP FP sub, you as the owner are going to generally have less ability to bring claims against the subcontractor. It's not always true. If there's a circumstance where there's an explosion or fire, something goes kablooey, your ability to sue everybody is greatly expanded. But if you're the owner and you're just dealing with disappointed expectations, this mechanical system has rooms that are really hot and other rooms that are really cold, or this system is completely inefficient. If your expectations are just disappointed, you might not, as a project owner, be able to make a claim directly against the design professional that was responsible for that MEP FP design. And why does that matter? Well, it matters for a number of reasons. And one is that if the agreement between the owner and the general contractor does not specifically address the fact that there is a bunch of design that is going to be performed, if there aren't terms that are appropriate for design standard of care, certainly insurance requirements, language that would allow the owner to make a claim directly against the subcontractor, what you can get stuck with is an owner that only has the ability to sue the general contractor for their dissatisfaction with the design produced by the sub. And one of the problems that you could run into there is that it's often the case that general contractors don't have the kind of insurance that an owner would want to have if they're bringing a design malpractice claim against the general contractor. Typically, the insurance carried by contractors are going to cover workplace accidents and a myriad of other things, but say that what's excluded is any claim for design malpractice. And so while it is true that you could sue the general contractor and then they could sue the subcontractor and get to the subcontractor's insurance, when you have this multi-party litigation, what you're really signing up for is a lot of hassle and expense, that's going to drag on in court for years and years and years. And so if you are a project owner or a real estate developer and you're going to do design build MEP FP or really any design build system under the general contractor, you have to think about what insurance terms do I want to have in the general contract, what insurance terms do I want to dictate be in the subcontract, and you want to think about not just making sure that the contract looks good, but giving the oversight that's necessary to make sure that the appropriate policies are actually procured. Because it's not going to make you feel great as an owner to sue a general contractor and say that, it's a good thing that we had the insurance requirements that we would want to have because there's design services here, only to find out that the general contractor or the subcontractor never bought the insurance in the first place, because that's the whole reason for insurance is, you're wanting to backstop the contractual obligation. It's probably going to be a hard fight if you have a claim against a general contractor that doesn't have any insurance. If they're being asked to pony up $1 million for a bad mechanical design, you're going to have protracted litigation and a bad outcome. So when you are an owner or developer and you're going to take advantage of design build MEP FP, you've got to think about not just how do I make sure that I'm going to get what I want and it's going to meet my standards and it's not just whatever design they come up with behind mystery door number 2, but what contract terms do I want to have? What insurance requirements do I want to have on this side of things, on the construction side? The agreement between the owner and the contractor, the agreement between the contractor and the subcontractor. What things need to be there that wouldn't otherwise need to be there if we were going to allow the design to be produced 100% by the design team that is operating under agreements that have appropriate insurance and other terms to address the risk of design malpractice?